Quantum legal is the emerging field of jurisprudence that addresses the unique challenges posed by quantum technologies. To understand the mechanical necessity of this field, we must realize that our current legal systems are built on classical physics, concepts of locality, distinct ownership, and predictable causality. Quantum mechanics breaks all of these. In a classical world, if you own a server in Asuncion, the data on it is subject to the laws of Paraguay. But in a world of quantum entanglement, where two qubits can be inextricably linked across thousands of miles, where does the data actually reside? If a quantum state is manipulated in Brazil but its entangled partner is in Argentina, which jurisdiction has the right to regulate that transaction? This isn't just a theoretical problem, it is a looming constitutional crisis for digital sovereignty. We are moving toward a law of non-locality, where traditional borders become functionally obsolete for quantum data. Deeply and honestly, the most urgent aspect of quantum legal is the quantum decryption deadline. The moment a cryptographically relevant quantum computer exists, every NDA, medical record, and classified document encrypted with standard RSA or ECC becomes an open book. Legal firms and government agencies are already drafting quantum-resistant contracts. From a DevOps and security perspective, this means the legal liability for data breaches is shifting. If you're not actively migrating to post-quantum cryptography, you may soon be found legally negligent for failing to protect data against a known future threat. Standard patent law requires a clear and concise description of an invention. However, quantum algorithms and hardware often rely on probabilistic states that are difficult to define under current IP frameworks. How do you patent a superposition of steps? Can a company claim ownership over a specific entangled pair of particles? Regulators are currently debating how to verify claims of quantum advantage to prevent market manipulation and fraudulent quantum washing by tech firms. There is a profound ethical and legal concern regarding the quantum divide, the gap between nations that possess quantum capabilities and those that do not. Nations with quantum sensing can see through stealth coatings and detect submarines, rendering current treaties on territorial waters and airspace effectively blind. The first firms to master quantum-driven material discovery or financial modeling will have an insurmountable lead, potentially triggering new antitrust laws designed specifically for quantum monopolies. Quantum legal is the operating system of the quantum age. It provides the rules of engagement for a world where information is no longer binary. By establishing these frameworks now, we are ensuring that the transition to a quantum society is governed by justice and transparency rather than chaos. This is the legal substrate that will hold our advanced technology together. We must redefine the concepts of privacy, property, and sovereignty to match the non-local reality of the subatomic world. Without this legal evolution, the hardware remains a liability. With it, it becomes an instrument of a stabilized post-classical civilization. To expand on the mechanical necessity of this jurisprudence, consider the liability of autonomous quantum systems. When an algorithm operating on quantum probabilities makes a decision that results in physical harm or financial loss, traditional tort law struggles to find a proximate cause. The probabilistic nature of the computation means that the outcome was never deterministic. We are moving into an era of probabilistic liability, where the law must judge the quality of the quantum model rather than the specific action of the machine. Furthermore, the global supply chain for quantum components, from dilution refrigerators to high-purity isotopes, is becoming a flashpoint for international trade law. We are seeing the rise of quantum export controls, where the shipment of a specialized component is treated with the same severity as nuclear material. This creates a complex compliance landscape for hardware firms. You aren't just managing engineering, you're managing a geopolitical minefield where the legal definitions of dual-use technology are shifting by the day. In conclusion, the jurisprudence of entanglement is not merely a subset of tech law, it is a fundamental reboot of the social contract for a non-local universe. As we build the processors of the future, we must simultaneously build the courtroom of the future. We must move beyond the classical boundaries of the 20th century to create a framework that can contain the vast, strange power of the quantum realm. This is how we ensure that this concept supports the rest of the roadmap, providing the stability and trust required for future technical concepts to thrive.